Hey everyone, it's John, and I'm here with Terry Johnson from Firearms Legal Protection. You guys know they're one of the sponsors of the channel. We're here at Wilderness Tactical Products today. They gave us some space. You guys know they make a lot of stuff that I use. And I want to talk about something interesting today. I want to talk about reasonableness. We talk about this idea, and I get it on the main channel all the time. People go, well, you can't expect somebody in the heat of the moment to be reasonable. And I go, oh, yes, you can. So I want to ask the expert, what does that mean, and how does that work when we're talking about legal self-defense?
Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers.
All right, so Terry, reasonableness. I hear people all the time that say, well, you can't expect someone in the heat of the moment in self-defense to be reasonable. What do you think of that idea?
That is a question for a judge or jury to determine. And when you talk about reasonableness, the biggest problem in this is what's reasonable to you may not be reasonable to me, may be reasonable to you, may not be reasonable to her, etc. So what happens is you get a group of people together called a jury, and they collectively determine what reasonable is. There is no bright line, per se, what reasonable is. Like you just mentioned, to someone who's in the heat of the moment, something may be considered reasonable to them. However, the people that are judging you
who are sitting later, considering with all the time in the world, until it's 5 o'clock on a Friday when they figure out they may have to come back Monday. It's funny how those things come into play, but there is no strict definition for reasonableness. It's whatever the jury, those 12 people, or that judge, if they're judges here in the case, decides what reasonable is. Well, and when we even talk about, from the perspective of, okay, if we want to try to put some objectiveness to it, it's what would a good, sane, sober, moral person do in your shoes in that moment.
Correct.
But I'm still have some subjectivity there.
Oh, absolutely.
Because who defines what a good, sane, sober, moral person would do? Now, but of course, then I start trying to think about as a self-defender, as a guy who is really, from my perspective, when I think about reasonableness, then I think those people on the jury should certainly think the same way I do, but that's kind of not how a jury works.
Well, that's a great question. What a lot of people forget, again, what is a jury? It's a group of your peers. You're a jury of your peers. What does that mean? That means anybody that is in your county that's over 18, pretty much registered to vote, that's considered your peer. Now, will John ever be on a jury on a self-defense case? I could probably tell you no.
Never going to happen. Why not?
Well, because what happens is this, they bring a bunch of people into a room and, they ask all of them the same question. This is one that I like, it's the presumption of innocence. And, it's a theory that, no matter what happens, you're presumed innocent, and the judge, reads this again and again, and it's up to the prosecutor to prove guilt. But here's what I say to people, people hear that concept, but they don't necessarily get it. I'll give you a prime example. If you've been on the major freeways around your town, you've probably seen someone pulled over, maybe spread eagle on the car, right? You drive by them, do you say, wow, I wonder what that person's presumed innocent of? No.
Right. What did that person do?
What did that person do? And when you're sitting in court next to your attorney and the jury comes in and the judge says, oh, they're presumed innocent, their first thing out of their head is, wow, if they didn't do anything wrong, what? They wouldn't be here.
Ooh.
Right? So you kind of start a little bit behind the 8 ball, even though you're given an instruction not to. But subjectively, we're already there. And now we got to put a group of people together. And how do we do that? The prosecutor will take a look at certain people. So let's say John's there and John gives his credentials, with active self-protection. I talk about self-defense. I'm an instructor, this, that, and the other. And I'm sitting there and I'm like, oh my God, I got somebody that gets it. I want this guy. This is the guy I want. And guess what the prosecution's going to do? They're going to get rid of him.
Yeah.
Then it's going to come down to me, and I'm going to see someone that the prosecutor's going to see somebody they absolutely like, someone who's anti-gun, someone who doesn't believe in violence,
Yep.
and they're salivating. Guess what I'm going to do? I'm going to toss them.
And what's that called?
Preemptory challenges.
A preemptory challenge. So they call it a preempt, is what it's generally talked about. And depending on the state, they may get 12 of them. They may get 6.
Depends on the state and the case. You know, like for example, Michigan gives you 12. And that 12 is only on a capital case where, you know, you could be doing up to life. Some cases you only get 6. But again, it just gets down to you got to play this game back and forth and hopefully get some people that will see reasonableness in the same manner that you see reasonableness.
So not in a self-defense case, but I can give an example where I got preempted on jury duty. And so there was
Told you.
Yeah, well, and there was a case involving a DUI. And the defense attorney asked, does anybody here have, has a drunk driver affected you? And I had to raise my hand. Yeah, I got rear-ended by a drunk driver in 2000. It cost me my commission in the United States Navy. It cost me a bunch of money. And he looked at me and said, nope.
Right.
And I got ejected out of the jury box. And it actually was great for me because then I got to go home, right? I didn't have to deal with the rest of it. But
you know what? I bet anyone who's looking at this would not say that you were an unreasonable person.
no, of course. And could I have, been reasonably sure that I could be objective and not hold against that guy what happened to me? Yeah, but the defense attorney didn't want to take that chance.
Exactly.
And so he just kicked me out. So what you're left with in a jury is the 12 people that both the prosecutor and the defense attorney did not preempt, or they ran out before they got to these people.
Correct. And it's kind of like, sometimes you look at what's in front of you and you're playing this little game. It's like, geez, if I'm out of preempts, do I want this person? I'm just looking at them and it's like, oh, if I stick with what I get here, am I doing the right thing? It's a game in there. It's a chess game.
So then those 12 people get to decide, in application of the law, with jury instructions and all that stuff, what is reasonable in this instance under the law.
Close. Not the application of law, but facts.
But the application of facts to the law.
To the law. Because what happens is a judge decides what the law is. It's the jury's determination of what the facts are. So if I say, I was in fear for my life, that's a legal standard. But the jury may say, based on this, this, and this, you weren't in fear of your life. That's a fact that they have to determine.
That's why we call them the finders of fact.
Finders of fact.
See, I'm learning things. This is why we do this stuff. Those little articulations matter. So then that reasonable standard, now let's back that up to me as a self-defender, right? So, of course, I never want to go to court. I never want to do anything. So why is this standard of reasonableness? It seems to me, I guess, that then I want to be conservative here. And I want to do what any reasonable person would want. Not my standard of reasonableness necessarily, but I want to be conservative there and not even go as far as I think might be reasonable because I'm running against what other people might not think is reasonable.
That is correct, but here's the thing you gotta remember, it's reasonableness where you are. So what's reasonable in, let's say, where we are now, Phoenix, Arizona, may not be deemed as reasonable in Boston, Massachusetts.
Probably won't.
But you can do the exact same thing here, just change the location, go there, do the exact same thing, and those people may not deem your actions as reasonable. So you have to be concerned where you are when you do what you do.
Yeah, definitely a thing about regionality, and not only state by state here in the U.S., but if you are in another country, Canada, or again, Mexico, or...
I'll make it even easier for you. Not only state by state, but county by county.
Yeah.
Because some counties have a different view of reasonableness versus, for example, in the Metro Detroit area, we have Wayne County, which is where Detroit is located. The standard of reasonableness there compared to Oakland County, that's law and order county.
Right. And I think in the use of deadly force, if we're talking about firearms use, that's why we talk about, at least I do, the difference between can I, should I, and must I.
Right.
Because there's times where I might be able to get away with using deadly force that I can, but I don't absolutely have to. But if I get to that must I, then I'm almost never going to have a problem. If I say, look, I didn't have any other choice. I had to use deadly force, or I was going to end up in the hospital or dead, or my child was going to die, or something like that, then then we've met that standard that almost nobody would argue with.
You know, I just thought of a situation in Chicago a few years back. You know, Chicago PD has been having some issues, and there was a female officer who literally took a beating as opposed to pulling out her gun. And they questioned her, why did you do that? And the reason she did it, she said, I didn't believe a jury would believe me, so I'd rather take the beating than pull out my gun and shoot someone.
Wow. Wow. And you know what?
That's scary, but she knows exactly the jurisdiction she's in.
And you know what? I've said many times to non-law enforcement officers, you know, when somebody says, well, wait a minute, am I just supposed to take a beating? Well, the answer is yes. I mean, physical force is not necessarily a justification for deadly force. And you know what? Sometimes you just got to take a butt whooping.
Right.
And that's not...
We've all taken them.
Yeah, we don't want to, right? But great reason to get to your empty-handed skills. So that's this interesting thing that reasonableness is not a bright line, but it's a very important line for you to stay on the good guy side of.
And know where you're at. Know what... You know, think of it this way. As a kid, you know, at home, you knew what you could and couldn't get away with. But when you went to grandma's house, the rules are a little different. Grandma's house, I can stay up a little later. I can eat a little this, but at home, no, mom's not having this. So what's
gonna get a whooping,
right? What's reasonable at one place doesn't make it reasonable at another.
Great point. Wow, we're gonna end on that. So Terry, thank you. I think this is an interesting one for all of us to really make sure we've nailed down, so that way we don't get into trouble. So thanks for the help, man.
Anytime. Thank you.